You didn't order anything before. We're all behaved. Great. Okay, we're going to get started. Thank you all for coming here in person in the room, and thank you very much for joining online. Recent years have seen a surge in interest in the ways in which social media and digital platforms intersect with health and consumer harms. Just in the last 2 years, we've seen a number of comprehensive studies investigating these issues, from the Surgeon General in the Biden administration issuing a social media and youth mental health advisory, to a study last year from the National Academy of Sciences on the relationship between social media and health, a study from the American Psychological Association issuing a health advisory on the relationship between social media use in adolescence. And as those empirical studies and empirical work has grown, so too has the public conversation around social media and health. There is increasingly widespread debate and discussion, including the New York Times bestseller Anxious Generation, which has turned many of these conversations around social media and health from a sort of wonky or academic conversation to sort of kitchen table conversation across the country. As those conversations and focus and attention has increased, so too has the use of litigation to contest claims around a range of harms with social media. And we've seen a rise of product safety and consumer protection litigation, in particular, raising a wide range of potential harms, including social media addiction. I think many may be familiar with the bipartisan group of attorney generals, suits against social media companies that have now been consolidated with thousands of claims from individual plaintiffs in a multi-district litigation. We've seen claims around the role of social media in access to drugs and sextortion, including a suit from the New Mexico Attorney General against Snap, alleging that Snap's the design of the platform, facilitated both sextortion, but also youth's access to drugs and guns. We've seen suits around dangerous challenges and behaviors, like TikTok's recommender system's alleged role in promoting a dangerous blackout challenge, or Snap's decision to integrate a speed filter into its product, which plaintiffs alleged encouraged kids to speed using the platform. And as plaintiffs and the government has turned to litigation, so too has industry. NetChoice has turned to legal action to contest regulatory proposals in state legislation in a number of states, including California and Utah, most recently in Maryland. So as litigation has sort of entered the fray, and lawyers and judges have assumed a central role in social media regulation here in the United States, collaboration and knowledge sharing between researchers, between litigators, between communities and groups affected by social media is more important than ever. So my name is Peter Chapman. I'm the Associate Director of the Knight-Georgetown Institute here at Georgetown, KGI. KGI is a nonpartisan institute focused on connecting independent research with technology, policy, and design. We really seek to be a central hub for a growing network of scholarship related to our online information ecosystem. And we seek to build bridges between disciplines and across the range of stakeholders who are increasingly relevant in technology policy, including, as this conversation will make it clear, judges and litigators, as well as researchers. KGI broadly works across two areas of tech policy: competition policy and platform governance. And in platform governance, we have a specific focus on data access, as well as platform design. Both of these areas of technology policy are implicated and contribute to ongoing conversations around litigation and social media. I think platform data access is essential, as we'll hear perhaps from Bryn and others, to actually assess and establish potential harms and benefits from social media. And it's also critical to identify effective strategies to prevent or mitigate harms. So I'm so delighted that we have the opportunity to unpack these trends with this group of people. And KGI is very excited to be co-hosting this event with Georgetown's Institute for Technology, Law, and Policy. And we're joined by four leading experts today who I'll just quickly introduce. Mitali Jain, to my left, is the founder and director of the Tech Justice Law Project. Meg, on the end, is the Provost Distinguished Associate Professor in the Communication, Culture, and Technology program here at Georgetown, amongst other affiliations. Matt Lawrence is the Associate Dean of Faculty and Associate Professor at Emory Law. And Bryn Austin is a professor in the Department of Social and Behavioral Sciences at the Harvard T.H. Chan School of Public Health. And you'll see quite intentionally this panel has quite an interdisciplinary perspective informed by public health, by law, and by technology. So this morning, I'm going to spend about an hour and 15 minutes in conversation with the speakers, but then we really want to have a conversation with this room. We have participants from government, from academia, from civil society organizations, and Georgetown students across a range of programs. And we certainly want to leverage the expertise in the room and engage in conversation. I think the flow of the session is really going to be to first start with kind of high-level framing around the current state of social media litigation in the United States, notably impacting Section 230 of the Communications Decencies Act, as well as the First Amendment and public health law. We then want to talk about some cases and emerging lessons that are coming out of the cases of the last 3 or 4 years. And then I think most excitingly, from my perspective at least, potentially look at some outcomes from these processes, these cases, and look towards future opportunities. And we really hope this conversation can enable us to collectively leave with new ideas, new questions, and new opportunities for collaboration. As we get into the conversation, one housekeeping note: restrooms are outside by the elevators should you need them. And of course, please feel free to refresh your coffee at the back of the room. So with that introduction, let's get into the conversation. I'll start with you, Mitali, and just ask you to sort of level set about the current moment we're in. What is Section 230 of the Communications Decency Act? How is First Amendment implicated by this litigation focused on digital platforms, and sort of where are we at this moment?
Sure. So thank you for inviting me to be part of this conversation. I always love partnering with KGI and my fellow panelists in these kinds of conversations. Well, what to say about 230? Much ink has been spilled on 230. It's, as some call it, the 26 words that really shaped the internet. It's a very controversial provision of a federal law that was adopted in 1996, the Communications Decency Act, designed to ostensibly foster innovation and development of the internet by providing immunity from liability for online platforms for hosting third-party content. And so, as I said, the intention was really to provide immunity from lawsuits that would have forced these online platforms to either take down illegal content and constantly be monitoring for that on their sites, or to not moderate at all. And this understanding of that provision really promoted this idea of free speech. So it was consistent with our understanding of the First Amendment. It is a law. I mean, I think we need to know that it was adopted almost 30 years ago at this point, when the internet looked very different. The internet has flourished, despite claims of liability from, users and so forth. And what we're left with today is a really expansive interpretation of Section 230 that effectively immunizes online platforms for any publishing that they may do of third-party content, but also for any activity that they engage in that's not content related, and content that they create themselves. The original understanding of 230 was really never meant to extend that far, but in fact, courts around the country have extended this 230 immunity shield to instances in which there's been evidence of real harm that is not attributable to third-party content. So the idea here was that really online platforms, if they were being treated as publishers or speakers, we're not liable. but it did not immunize platforms for developing their own content or their conduct. And so, there's at this point, different circuits have handled their interpretation of Section 230 as it relates to various tech claims in different ways. From our perspective as advocates for accountability, I think we're most invested really in the Ninth Circuit's articulation of the three-part test. Around 230, it's really the most sophisticated test in the country. And according to that circuit, 230 protects, number one, providers or users of interactive computer services. Number two, but only if the plaintiff in a suit seeks to treat them as a publisher or a speaker. And number three, of information provided by another information content provider. So we'll get into it, but of course, when you start to see claims alleging that there's an internet product that's defective, that ceases to treat that platform as a publisher or speaker and really starts to look at its own material contribution to whatever the defect is that's been alleged. Nevertheless, courts are really in a mess around 230. And I think there have been attempts to really widen 230's scope as platforms become entrenched in the consumer economy as social media companies, but also as marketplaces that are selling harmful products, designing harmful features, and misrepresenting how they govern their marketplaces. And so the Supreme Court had an opportunity a few years ago to look at Section 230 in the context of a case called Gonzalez v. Google. It sidestepped that probably for the best, given the way that case was going. And so we don't really have at this point a statement from the Supreme Court about the limitations of the proper application of Section 230 as it relates to technology. And then just quickly to level set on the First Amendment. So the First Amendment is kind of, this constitutional protection that companies also often invoke to immunize their conduct. And so what I often refer to this as is a 1-2 punch. Companies will assert both a Section 230 claim as well as a First Amendment claim and kind of gamble which one they can get protection under. And if they get protection under either, it's game over, frankly, for plaintiffs. But in my view, the First Amendment rights that corporations assert in the tech context is very much a outgrowth of Citizens United and progeny that really have invested corporations with increasing amounts of constitutional protections. And so Citizens United, of course, was the case in 2010 that provided unlimited corporations with unlimited rights to influence political campaigns. And so what we've seen vis-a-vis the First Amendment is that tech companies assert that their moderation activity, that all their activities online are moderation activities, that they assume the role of an editor, and that is free speech protected. Thankfully, we did see the Supreme Court recently put some limits down on the First Amendment as it applies to tech last summer with the NetChoice v. Moody case. In that case, Florida and Texas had basically enacted regulations at the state level to tell social media companies how to moderate their content. That went up to the Supreme Court, and the court, I think, rightfully said, look, when you're engaged in actual content moderation, that is an editorial function that is protected by the First Amendment. We wouldn't want to prohibit, that type of behavior from occurring. But companies cannot weaponize the First Amendment and endlessly expand it to applications where it really, may not be well suited. And so the Supreme Court threw the case back down to the lower courts because it said, number one, the factual record here is not developed. NetChoice, which is a collection of industry, it's an industry kind of trade group of different companies, about 40 different companies, has asserted that their First Amendment rights have been violated. Well, how does, Etsy's First Amendment rights compare to Facebook's First Amendment rights? We need more facts to establish whose rights are being implicated for what services and what activities. And so I think the court rightfully said, when you're challenging a law before it's been enforced, you need to develop a factual record and really show us what it is with specificity that you're alleging is violative. Also, they rejected this categorical approach and said, we're not going to say that all online platforms are editors. We're not going to say that they're all utilities. We're going to look at each case on a case-by-case basis to say, in this instance, what is the online platform acting as? And then decide accordingly where the First Amendment rights attach. They also noted the inconsistencies between 230 and the First Amendment and the way that tech has been, using them as a 1-2 punch, and effectively said you can't have it both ways. You can't both say this is third-party content for which you're not liable, but then turn around and say this is your speech. And so I think what we have, and then I think the final thing for our purposes, for advocates who are thinking about how we apply Moody on the ground, is to say, the court left open two Easter eggs, which were that, when you have engagement maximizing algorithms that really are designed based on tracking user behavior online, that may not be protected by the First Amendment. And secondly, and this was not necessarily the central holding of the case, but certainly, mentioned, Judge Coney Barrett actually said, look, as we start to get more and more sophisticated with AI, there is an attenuation between the paradigmatic notions of the First Amendment, which are really about expression and being able to kind of, be protected for your expression, and, the technology. And so it may be that we had to have a different First Amendment analysis as machines start to play that role increasingly. So that gives us great hope. But yeah, historically, we have seen, these two legal, devices being used by tech to insulate themselves from accountability.
Amazing. Thank you, Mitali, for that sort of crash course on internet law and the First Amendment. I think many of those themes will come up as we move through the conversation. And so, Meg, maybe turning to you, you've worked with litigators and enforcement agencies and attorneys general on questions and issues of digital platforms and design and privacy. From your perspective, what opportunities does litigation present in this place, particularly taking a sort of consumer protection or product kind of focus to advancing platform accountability?
Thanks, Natalie, for that crash course. You've teed me up really nicely. It's only recently, I think, that politically we've been willing to say anybody other than technologists and tech companies should have anything to say about how the technology works, how it should be designed, what data should be used. And that, I think, has happened as people have tried to get creative, creatively work around Section 230. And two of the places that we have seen states do this is with data protection laws and with design codes. My theory of change and how the world, how needles get moved in the world is hungry lawyers. And so I think litigation is the essential part of this story. And we have seen some really successful litigants in especially state data protection laws. And the design codes have been less successful, but are still coming up. They're still adapting. States are still adjusting as courts make different decisions. But where we've seen the most success is with simple laws. So Illinois, my favorite law as a privacy scholar, is the Illinois Biometric Information Privacy Act. It's a simple consent law that you can then sue if your rights are violated under that law. And it's been very successful because it taps into the hungry lawyer theory of change. Design codes are now really popular, and we're seeing them also work through states. These usually have a couple of different elements. There's usually a kid part that's you have to treat kids a little bit differently. There's usually an addictive design feature to them. And then there's usually a risk assessment and a design and a disclosure piece to those codes. Those have gotten mixed treatment on the First Amendment each different element as it's gone up through the district courts. Most of them are being appealed. Maryland's will get a hearing shortly on Maryland's design code. But this is really net choice is like the advocate on the other side of this. So all of these are net choice cases, and they have a really clear strategy going up against these design codes, and they are to Metalli's point that this is all speech, these are all editorial decisions, and this is all really about content and how content gets produced through the data and the design of the platform. The last thing that I want to mention that we didn't talk about before, but is that many of these laws are about kids, and they require platforms, if you want them to treat kids differently, to know who a kid is. And this triggers all kinds of different legal analysis depending on how the states structure that. So California's design code is likely to be accessed by a child. The Supreme Court is now they're deciding a case that is real age verification from Texas for kids to access pornography sites. So this is, you have to age gate your users as they enter a pornography site. So those will have different analysis, and it's an opportunity, like Natalia said, to recraft or edit this First Amendment analysis that's been on the books for quite some time.
Right. Thanks for that, Meg. So sort of maybe broadening out a bit, Matt, where does public health fit into this? I think you've written about how the sort of internet paradigm is grounded in these paradigmatic national standards, CDA, First Amendment, whereas, the public health paradigm has historically privileged federalism and the role of the states. I'm curious how public health law is entering into this equation, or how public health approaches are entering into the equation in relation to social media.
Yeah, so Natalie mentioned the Gonzalez case that went to the Supreme Court where they had to figure out about 230, and they kind of punted. And there's also that famous quote of, I think it was Justice Kagan saying, like, we're not exactly the world's greatest internet experts or something like that. And I think the Supreme Court's struggling with the question, which is like, where's my phone? If I said, like, which is this most like to you? Is this most like a book or a slot machine? Like if I ask you to raise your hand, it's most like a book. Raise your hand. Raise your hand, slot machine. It's most like a book. So we have some, and then a lot of you are like, I don't know that I want to say it's most like one of those things. Like it's a phone and it's different and it might depend. And so the Supreme Court is dealing with case law because they're a court that's been built around there's, gambling, drug addiction, public health case law. And then on the other hand, there's violent video games was a famous case, books, case law. And these are very different kind of ways of thinking about harms to users and to product design. So public health is historically state and local. Of the Latin quote I wrote it down is Salus populi suprema lex. That's from Cicero. Okay, so that's a 2,000-year-old quote that says the law of the public health is the first law. And the idea is that you can quarantine a ship that came into port because it has Black Plague on it. Right? You can build a sanitation system. You can, which they did in the beginning of the 20th century, force a shot in somebody's arm to vaccinate them against smallpox. Why did public health do that? Because 250 million people died of smallpox in the 20th century. This century, it's zero and will be zero because we forced shots in people's arms and we eradicated smallpox. And so public health goes with state and local can kind of do what they need to do to protect public health. And the case law in this space, we see some questions about like federal authority, like what can we do here from DC? But if down in Atlanta or in Georgia, we want to do something to protect the public health of Georgians, like we can do it. So you can regulate a kid's poster they can hold up. They can't hold up a poster that says bong hits for Jesus, even though that's speech, because you can try to protect kids from drug abuse and things like that. So you have pretty strong case law of like state local control in the public health area, even against constitutional interests, even against freedom of speech, we have state interests that trump. And that's like the public health perspective, but then totally this kind of internet perspective. And so if you go to a tech conference or a privacy conference that doesn't have public health people in the audience, then often they're thinking of, well, the internet is Section 230. There's not just a tradition, there's the opposite of state and local control. It's Section 230 is pushing out state and local control. If we down in Georgia want to regulate platforms in some way, sorry, people in DC said no back in the late 90s, you can't do it at all. So it's a completely opposite kind of a paradigm. And then when you also get to constitutional protections, regulating a phone implicates freedom of speech. So does putting a shot in somebody's arm implicate their bodily integrity. Both of these implicate constitutional values. In the public health world, courts are often very willing to say, but there's a state interest in protecting public health. But in the internet paradigm, it's often, oh, we're very worried about interference or something. So I think that there's just conceptually, you can often kind of predict where a person's going to come out, or even a judge is going to come out on regulation in this space, based on whether they come in thinking in like a public health problem and thinking of the thing like a slot machine, or if they come in thinking of it as like a technology problem and like reading a book or something like that. And so conceptually that determines it. And then to get more nitty gritty, also just like doctrinally, the kind of public health, state authorities and state interests, like states have a compelling interest in protecting the public health. They have a compelling interest in protecting the psychological well-being of minors. And there's other state interests here that can trump even freedom of speech, right? There, if you draw a Venn diagram of like what they protect, and then you draw a Venn diagram of like what the First Amendment protects, like literally the doctrinal fight in some of these cases is this in the protection of the freedom of speech? And then if it is, might it be potentially kind of protected by, justified as a state interest? And the Moody decision from the Supreme Court that Vitali got to, there, the Supreme Court, I think it's the whole thing's technically dicta, but it's not, and all of that. But in a way, what the court said in that case is, don't just decide if this is a slot machine or a book. Instead, you need to go app by app or function by function within the app. And if TikTok, as has been alleged, is spacing out engaging content the way a slot machine spaces out rewards, then we'll treat that like a slot machine. But if, on the other hand, the app is Kindle and you're reading a book or something, then it'll be, and Moody seems to say we need that function by function analysis. So anyway, that's one way of thinking about it.
You want to come in there?
Oh, I just loved that.
Yeah.
Yes, I'd want to say I loved that.
Yeah, completely agree. And I think there are two themes that we really want to draw on, which is really the state interest piece and then the role of specific design elements. Because I think the state interest piece, when you come with a public health perspective, is obviously informed by evidence. So turning to you, Bryn, as a researcher, you've done extensive research on social media and teen mental health, especially for teens struggling with body image or eating disorders. And so I want to kind of bring in the public health research perspective and ask you sort of what is the research saying about these links between social media and types of harm that are being alleged in these cases?
Great, thank you. And thank you to my fellow panelists. This is such an education. It's fantastic. And I appreciate the opportunity to bring in the social science, the teen adolescent mental health science. So I'm coming from that perspective as a specialist in adolescent mental health and eating disorders. So we've known for years the ways that social media is having harmful effects on teen mental health. And some of the first research from my area of the world actually were eating disorders specialists. They were having their patients come in ages ago, were coming in talking about how they learned their eating disorder behaviors online. So there was some early research there starting to connect the dots along those lines. And where we particularly see the research finding strongest results is around body image, anxiety, depression, and eating disorder symptoms. We see this in adolescent girls in particular, but really across all genders. And what we see particularly is around the way that engagement algorithms can send young people, especially teen girls, into a dangerous spiral of what we refer to as negative social comparison or upward social comparison. That's one element. I'm going to come back to that in a little bit now that more research has been able to parse out what the pathways might be. I'm going to give an example of it. Imagine, so anyone who has been or knows teen girls will have seen this on their phones, on your phones. But others who aren't getting those kinds of algorithmic feeds may not have seen it to this extent. So imagine that a teen likes a post about an extreme diet or a post about with before and after pictures of weight loss, or what's very common now are posts on what I eat in a day. These types of posts we know are associated with worsening of body image and eating disorder symptoms. So if a teen engages with that, the engagement algorithm will then amp up those types of posts so that the teen will see more and more of these, and that will become increasingly extreme in terms of what the messaging is in these types of posts. And then even more insidiously, we know that the way that the engagement algorithms work in posting ads is that the kinds of posts that troubled users or users that we refer to in the eating disorders field as pro-ana, they refer to themselves that way. Pro-ana meaning pro-anorexia nervosa. They are purposely posting very disturbed content to promote the idea of having anorexia. So these pro-ana posts are then used to place mainstream brands, 14 brands of ads. So what you imagine that 13-year-old or that 15-year-old seeing is very disturbed pro-ana content right next to any number of mainstream brand ads that are showing up next to this kind of content. What the teen is seeing in this case is an increasingly extreme and continuous feed of toxic content. So that's on the content side there. And it was the early studies in eating disorders that were identifying some of these patterns. Early studies also flagged displacement of sleep and physical activity. And I mentioned the negative or upward social comparison were what early studies were flagging. The displacement of sleep cuts across many kinds of mental health and physical health issues. When people aren't getting enough sleep, and in the teen years, people need more sleep. Developmentally, they need to be sleeping more. When they're not getting enough sleep, it affects how they can perform in school, how they can focus. It increases the risk of accidents. And for people vulnerable to mental health struggles, not getting a healthful amount of consistent sleep can also worsen their symptoms and potentially provoke an incident of if they have more serious mental health. So the older studies have provided great clues, useful clues, but they also didn't have the strongest designs, which is just how a field evolves. Much more recent studies are using more rigorous designs, like experimental designs, longitudinal cohorts. That's when you're following the same group of people over time, ideally years. And they're using more precise measurement of social media. I remember go back 10, 20 years, a lot of the public health research was looking at screen time with the idea that any time that someone might be sitting and looking at a screen is the same. That's not, we know that's not the case at all. So more precise measurement of social media. So what we're seeing now in the more recent experimental designs and longitudinal cohort studies following young people over time from early adolescence through middle or later adolescence, what we're seeing is that it's the image-based platforms, especially these visual platforms, are where we're seeing the strongest connections around teen mental health and around body image and eating disorders. So this is where we have the most concern around that. We're seeing over time worsening of eating disorder symptoms, worsening of body satisfaction, which is a kind of metric we look at, worsening of body dissatisfaction over time in young people. Suicidality, we're seeing over time with this more rigorous kind of research from these types of designs. I want to cover one other area of research before I wrap up, and that's from the neuroscience and the psychological research related to the neuroscience, and then what the neuroscience is finding about adolescent brains. So from a psychological perspective, and especially thinking about these visual social media platforms, the two kind of pathways we're especially concerned about in the eating disorders field are the upward or negative social comparison. This is natural. This is how all of us and teens especially learn how to live in society. You learn your place in society, learn the social norms. It's through social comparison. But when this is hijacked by the way the algorithms work with the negative or upward social comparison, where people are presented unrealistic images, unrealistic kinds of diets, weight loss, that's where you can lead to the real mental health struggles and the worsening of the anxiety and eating disorder symptoms through that process, and what is a natural process, but gets hijacked with the upward or a negative social comparison. The other is the internalization of a thin ideal. In our culture and in a number of societies, there's a hyper focus on thinness as if it equates with health and virtue, not just the belief that it equates with health, but also with virtue. Like there's moral value in being thin. This is what teens are learning, and especially teen girls, but really kids of all genders are learning through the kind of messages they're getting in, especially in these visual social media platforms. They internalize the ideal, and then they experience enormous pressure to try to achieve that. And they're reminded through this feed that they're not reaching it. They need to become more extreme. For vulnerable teens, these two pathways are particularly powerful. And I want to say a little bit about the teen brain. The teen brain is distinct from younger children and adults. So it's not that all children under the age of majority, under 18, are the same. Their brains are very different. And there's three aspects of the teen brain that I want to highlight from the research. Through normal adolescent development, teens have heightened sensitivity to peer feedback. As I mentioned, this is how you learn how to behave in your society, in your community, what's valued, what's not valued. That's where we learn that. So teens, more so than young children and more so than adults, have very heightened sensitivity to feedback from peers in particular, and social cues from peers. And this has to do with the parts of the brain that are developing faster. And that's the second point I want to make, is that the brain doesn't just develop at a unitary pace through the entire brain through adolescence. There's actually an unevenness in what regions of the brain are developing first, second, and later. That people talk about how the brain is not fully mature till around the mid-20s. What they're talking about is the reason, the impulse control, the decision-making parts of the brain don't develop till much later. What develops first are the processing of emotion. And this naturally uneven pace makes teens more vulnerable to emotional types of prompts and triggers. I mean, people say there are movies about emotional teens and adults looking on, why are they so emotional? Their brain is wired that way. This is part of natural development. But it makes them particularly vulnerable to emotional cues in social media. This lopsided neural development is what is being exploited in the way that engagement algorithms are working. And the third point is that naturally, because of development, teens are more sensitive to social rewards as opposed to monetary rewards, which adults will be more responsive to. Social rewards are something that also the social media platforms are designed to exploit. That could be through likes or notifications or number of followers or people commenting on posts. These are social rewards that teens are wired to be most responsive to because of where they are in their developmental stage. So with these three neurodevelopmental kind of vulnerabilities, social media engagement algorithms are designed basically explicitly and perfectly to exploit that in teens, which is why we're most concerned about what's happening with teen mental health as opposed to the younger children or adults online.
Super helpful. Thank you, Bryn. I think, Matali, turning back to you, I think both Bryn and Matt talked about really specific design features and the roles of those features in relation to harm. And as we've seen the litigation evolve, claims are much more specific around design features and design elements of platforms, whether those are recommender systems, variable rewards, gamified engagement. Curious what types of claims appear to be sort of navigating this terrain between Section 230 and the First Amendment as it relates to design.
So, I mean, I wish I had a very simple, straightforward answer for you. And one thing I will say is we, together with KGI, last fall developed a series of documents that provide, hopefully they serve as resources where we've tried to map the key litigation around Section 230 as it relates to design and the First Amendment, over, I'd say, the last 15, 20 years, so that you can see for yourself kind of both some of the trends, but also the inconsistencies between courts. The fact that, courts in one circuit are ruling one way and in another circuit another way, and then courts in the same circuit are ruling different ways, which we had just last week with the California Age Appropriate Design Code, where frankly the judge ruled in a manner that was different from her fellow judge in the same courtroom, the same courthouse in San Jose on engagement fees. So we do see a lot of inconsistency, but I'd say as a general matter, we are starting, I think, to see real openings using a design-based approach, a safety by design approach, where you can talk about the problematic features as being design-based and therefore content agnostic. So the point of intervention is upstream. If you think of it, visually, you're intervening at the point of, how are these things being designed as opposed to downstream in terms of what content are users seeing. Now it's hard always to thread that needle. But the claims, the design claims that, we've seen some kind of momentum on, I guess, would be things like the platform's failure to warn, parents or users about certain harmful products on the site, negligence. We've seen the gamification type features, like Matt said, where, judges are kind of compelled by this idea of slot machines being somehow perhaps addictive or, somehow just, not deserving of 230 protection and First Amendment protection. Some courts have looked at infinite scroll and autoplay as design features that they say don't get that kind of immunity. Barriers to deletion, like with the Amazon, it takes you how many, I forget if somebody knows how many steps in order to delete your account, but like that becomes friction that the company has introduced to keep you on the site longer and to keep you engaged. So all of these things I think are, places where we have started to see some really positive momentum. The other place that I think has been consistently positive has been where you can allege that algorithms are discriminatory, having discriminatory impact on protected classes. I think courts have said that that does not get 230 protection. Of course, it's difficult. I mean, we're going to talk about evidence. How do you demonstrate that discriminatory impact? But that's another area where we've started to see it in fair housing, in who receives life insurance, who receives job opportunities, that kind of thing. So I'd say those are some of the areas. There's also kind of, does the platform recommend contacts to users, particularly minor users, recommend contacts with adult strangers? Things like scams or being able to have the tools to engage in the production of deepfakes. These are all things that, one could argue are content agnostic, and some courts have started to see that. But again, I think, we haven't seen full consistency across the country.
Mm-hmm. That's great. And I think with each of those claims, of course, evidence is central to the court's analysis.
Completely.
Of that. And I think evidence can mean different things to a lawyer or to a doctor or researcher. And so, Matt, turning to you, you recently had some commentary about sort of 5 areas of potential disconnect between the public health field and the legal field as it relates to these cases advancing consumer protection. I would love to hear you describe those dynamics and their importance.
Sure. Well, if you read like some of the debate and popular debate from the Jonathan Haidt book, and then there's been response like in the Atlantic from researchers, and he makes claims in the book about social media contributing to youth mental health crisis nationwide, and then mental health researchers might respond about that. And that's an important debate, but the kind of core point I want to express is that that's not the debate that's happening right now in courtrooms. So let me give a couple of examples of cases and how they fared. One case is VV v. Snap, and that's about a young woman. She was 12 years old, downloaded Snap without her parents knowing, winds up getting pushed eating disorder and sexualized content. It affects her sleep. Then Snap's quick ad feature suggests she get in touch with a sexual predator. And then she suffers really kind of horrible results, as you would kind of predict from that. And she was then recommended another sexual predator. They sue. And of course, the allegation of that suit is not there is a youth mental health crisis being caused. It's like you recommended that sexual predator talk to me. But then ultimately the court said, well, Section 230 says that if they just matched you with that person, that's protected editorial discretion, regardless of the allegations, case dismissed. And that was the kind of final result in that case. And then a second case is Patterson v. Meta. This is a case that arose out of the top supermarkets shooting. That was where a man he'd been kind of indoctrinated in white replacement theory, and he went and had this racially motivated killing in a supermarket. And dissidents sued, and they alleged that Meta's addictive design of the device had gotten him kind of looped into this scrolling, and that had led him to the white replacement theory content. And again, of course, the platforms come in and say, regardless of the truth of the allegations, even if they were true at a motion to dismiss, court, you should not hear this case because it's protected by Section 230. But in that case, the court said, well, actually, the way this was pled, the allegation is that the design of the platform was addictive. That's what got him kind of engaged. And then ultimately, yes, he was led to white replacement theory content, just the way a 13-year-old girl might be led to eating disorder content. But it's actually that content is downstream from the addictive design, which is the kind of engine that got the person hooked in the first place. And there said this case can go past, and I'm elaborating on a very short, motion to dismiss. There, that case is now on appeal. The court allowed it to go through. And so now it's being appealed in New York. I'm not sure if it was recently argued or just coming up or something like that. I lost track of that. So those are two very different outcomes in two different cases, one of which proceeding, one not. But the kind of core point there is that that's a flavor of the legal disputes. And it's not about the etiology of eating disorders. It's about, courts are not focused on that. Legislatures are focused on that. Medicine is focused on that. Parents are focused on that. So now let me get into some of the points.
Yeah.
First is just on the question of what is causation and what causal standard do we use. Different disciplines in medicine, neuroscience, epidemiology, use their own causal standards to assess what's good evidence, right? In a courtroom, you also use causal standards. Those vary, it's legal causation. They vary by the nature of the case. If it's a criminal case, the causal standard is beyond a reasonable doubt, right? If it's just a civil case, then it's more likely than not. And then courts also imply like proximate causation and the like. The point is just that the causal standards vary from one context to the other, and evidence that might not satisfy a neuroscientist yet as to showing causation, especially of a nationwide epidemic, might still be very probative in an individual case about like how it impacted an individual or something like that. So that's just like one disjunct between the two fields. And then I'll say another just couple to flag is that medicine and public health are very focused on patients and diseases. But especially as Mitali was explaining, the way that kind of cases are developed, courts are focused on the products and their design. And so just as a first point, evidence about a particular design feature, regardless whether that design feature winds up contributing to extremism or eating disorders or, you name it, the court needs it all to figure out what's going on with that design feature. Whereas, a particular disciplinary field might be very focused on like, I study eating disorders. I don't actually care if that design feature, or at least they might not be talking unless they're kind of thinking about that.
I do care.
Oh yeah, no, I don't do that. No, Brent, and actually everything you were saying, Brent, I was like, okay. So, and then I'll say one more thing, which is the courts are also, because of the First Amendment, very focused on whether we're looking at content neutral design features or design features that kind of discriminate among the content that's being promoted. So if a study is focused on infinite scroll or something like that, that the court might find is content neutral. That's not judging which content is going to be prioritized. And so it wouldn't trigger the First Amendment. And then it's a lot easier to regulate for a state because it's content neutral, just much, much easier to regulate. Whereas if, say, a state law were focused specifically on like eating disorder content, then that is discriminating based on content, and their courts for the First Amendment get much more suspicious. They apply more stringent tests. It doesn't mean you can't regulate there, but like, you're likely gonna have to focus on minors, and you're not likely gonna need a better evidence base. And again, that's just a place where the more researchers are kind of doing both things, the more they can inform, evidence-based judicial decision-making in this space.
Really helpful. So I think we now sort of have that kind of overarching context. We have sort of flavor of some of the cases that are moving through the system. The role of industry sort of challenging regulation and state interest has also come up. As we sort of look, now sort of towards the future and potential outcomes from some of these cases, Meg, I want to turn to you because you've been thinking and writing about sort of the notion of regulatory dynamism in today's information economy and sort of how some of our current institutions maybe struggle with some of that dynamism and the role of platform litigation coming into this space. I'm curious, how do you feel like these cases might help promote that type of dynamism as we move forward?
I'm going to answer that question by talking about a bunch of projects that I do with a guy in the room awkwardly sitting in the back, Paul Ohm. So everybody wave to Paul. Yeah, so we have a bunch of different projects that touch on this. And the first thing I will say, though, that opening up litigation beyond agencies, I think, would be the most powerful thing that we could do to produce more evidence. So evidence through discovery, I think, is one of the most powerful things that we can do because so much is opaque to us on the outside of these technical systems. Another aspect of this is when policies are drafted, they are done so in a way that users and researchers can actually see the parts that matter. So for example, if you have a purpose limitation and that's the heart of your way you're gonna like protect people, you give your data for one reason and you can't use it for ads about sensitive, subjects. That's really hard to see. We actually, like, as researchers, so we, Paul and I's lab, the FULAW lab, we come up against this where our students want to do a project on purpose limitation, but really the AG's office just has to sit there and wait for a consumer to think that they have been targeted by something inappropriate. And this does happen. My favorite example is a woman whose doctor told her to buy a pregnancy test from Walgreens because she was worried about some aspect of her recovery from ovarian cancer, I think. Was then sent a big gift bag of like baby formula and like baby products, and she posted it on Twitter. But like otherwise, and she didn't report it to the AG's office. I think somebody then handed that post off, to a news organization, and it got some publicity. But that should not be the enforcement strategy. That should not be the way that we're like tracking down evidence. So either setting up these laws so that we can see the parts of them that matter, or force disclosures of the pieces that matter would be really helpful. Paul and I also work with a Georgetown law scholar named Julie Cohen on this project called Redesigning the Administrative State that calls for significantly more visibility and testing. And it goes as far as proposing like A/B testing where there are social mental health ramifications that wouldn't be actionable on a injury in fact kind of litigation standard. But we've also pushed for way more intervention in design. So design guides, we're doing a project this spring that looks at disgorgement. So like meaningful enforcement is really important to these two. One of the other pieces of this litigation part of this broad like tech policy push are consent decrees to get out more of that information and evidence that we're talking about. These are legally binding agreements, but they don't have to worry about the First Amendment. So you can get really creative there. You could ask for researcher access on a periodic basis, that those have to be published, things like that. So I hope that litigators and judges are getting more creative. And then the last thing I would say that I would really love litigators and judges to recognize is the project Paul and I are working on now, which is this claim that the cost of redesigning platforms is way cheaper than almost any other regulatory burden that we've put on companies in the past. That software is modular and it's manipulable, cheap, and Paul will tell you how AI makes it even cheaper. And so when you hear this response from tech companies that this is impossible, this is impossible, probably not impossible. It's probably just really expensive. And when they say it's really expensive, it's probably not even that expensive. And so really pushing back on those burden claims and asking for evidence of that, I think is another part of the conversation that's essential to the doctrinal analysis.
Yeah. Amazing, super like concrete suggestions. And I think, Bryn, turning to you and sort of maybe this point around creativity that Meg brought up. You have a paper coming out in the New York Academy of Sciences on social media harm abatement that Alyssa Cooper and I from KGI collaborated on, as well as Nate Lubin from Berkman Klein Center and others. And it's focused on how courts in some of these cases could construct a sort of public health informed abatement mechanism that pushes the research and sort of supervision forward. Can you share a little bit about those recommendations and that process?
Yeah, certainly, certainly. And I appreciate your bringing up, Meg, that there is more opportunity in the court cases than you were talking about, Matt, the barriers that legislators have. They can pass a law, but if it can't pass muster with section 230 or the First Amendment, game over, as you put it. But with court cases, those are not, the settlement is not constrained by First Amendment or Section 230. So that's where the creativity comes in. So as you mentioned, in a team led by our colleague Nate Lubin and others.
And Matt, sorry.
And Matt,
Yeah.
yes,
Nate
Lubin led, and a number of experts in the room were part of coming up with a strategy for abatement plans or settlement plans, and working from where there's a long history of product safety litigation. An important piece about this being a basis, the product safety litigation, is that it doesn't need to be restricted. The settlement doesn't need to be restricted to monetary claims for the plaintiff. It actually can include remediation efforts, things to change what led to the problem in the first place. And that's what opens the door to all kinds of creative work that can be done through the courts in that way. So there's a few in this article I highly recommend. I think we'll be able to share it because it's a pre-press version of it is online now. So we'll be able to share that with folks in the audience. In thinking about an abatement mechanism, as it's referred to, they need to be able to legally operate within the scope of a court decision. So it needs to make sense for that precise case. But it also needs to be ambitious enough to deliver actionable data. We've heard how much researchers are constrained by the barriers to our accessing data and the secrecy of these platforms. They're not compelled to be nearly as open about their products, the safety, the data, as pharmaceutical companies are. It's actually very different. And then we need to be able to identify and measure specific potential harms so that these can be monitored. Now, there's a lot of research in this realm, but again, we're constrained by what kind of data we have access to. So with these things in mind, some of the technical capabilities that any abatement plan is going to need is, as I mentioned, measurement of harm in a representative population over years. So what the platforms generally are doing is measurements that are a very short time frame, maybe in the immediate same day, same hour, weeks, but we need to be able to follow people for years. We need to be able to assess when there's product or operational changes. We know these platforms are changing all the time. The research has to be able to be flexible with that. We need benchmarks, of course. We know benchmarks are being used inside companies to monitor how changes are affecting profits and that kind of thing. We also need those benchmarks to see how they're being affected. And we're going to need assessments for subpopulations. One of the ways that the industry hides from what the research is telling us is they can talk about the effects on the aggregate, the whole population. But what that does is it misses where there are certain populations that are most vulnerable. If there's certain populations being discriminated against in like racist housing ads, or if there are certain populations being targeted, as I mentioned, teen girls being targeted with very toxic content and amplified feeds around that, we need to be able to study this. So what we proposed in this thinking about abatement plan recommendations is a two-pronged system. There'd be an internal mechanism and an external mechanism. And I'll say a few words about each of those. The idea with the internal mechanism is how the court can compel companies to be doing that experimental research in a way that's more designed to be for the public good instead of just designed to maximize profits. The kind of data they're already collecting inside companies, experimental designs of changes over short periods in response to the changes in products, feeds, different kind of features, these kinds of things. And they'd also need to have what we call in scientific research a control group, or what they may call a holdout group, so that we're doing that experimental design. The external mechanism is where we have to bring in scientists from outside. We're not working for the company, or not reporting to the company. And this is where scientists who are university-based or based in civil society watchdog groups using longitudinal cohort design. So a large sample of people where we can do surveys, we could do biomeasures, we could do health records, and ideally we'd also have access to their feeds so that those could be analyzed. The the internal and external mechanisms are what we're proposing is what the courts need to be thinking about in these abatement plans. And I'll just say one last word, is that often the courts are left to themselves to figure this stuff out in a very short timeline. They don't have access to researchers to spend a few years developing ideas for them. So having this paper come out now and is available, we want to get it in the hands of people involved in the litigation, to state AGs, to others maybe in the federal government, or thinking about ways to holding companies accountable, and not just accountable, but for the harms, but accountable for making a safer ecosystem and on social media.
Great. Thanks, Brent. I think, we've heard now the sort of evolution from the rise of Section 230 in the Communication Decency Act, the sort of emerging public health and consumer protection litigation in some of these areas where we hope litigation or the panel hopes litigation might open up data access and potential oversight. A final question I'd like to ask just to each panelist is really about the future and sort of speculating about the next few years. I think, we have cases that have moved to discovery, the JCCP in California, the MDL company officials are being deposed in that litigation. So you have cases moving beyond an area where, Section 230 or First Amendment sort of protections were enabling these claims to be dismissed. So it seems like a good time to be thinking about the future and what potential outcomes could arise from these cases. So if you were forced to speculate, and I might start with you, Meg, and then we can just go down the panel, sort of where do you see where we're headed? What do you think will be the status of litigation against platforms sort of 3 to 5 years from now?
I do not have to be forced to speculate. I have a bold prediction.
Okay.
I think age verification is going to be found constitutional this spring, and where it's going to change the game.
Okay.
For a bunch of these laws and a bunch of these cases. And I think that's gonna consume what gets litigated.
What do you think the impacts of that initial finding will be?
I think you'll see a bunch of states, we have like a array of like how you should know somebody's a kid. And a bunch of those are struck down because it's just based on what it looks like. You can't really tell how you should do that. So it's vague. There's all kinds of problems that courts have found with it. Some have not. But finding that age verification is constitutional, like the most the kind of highest level where you actually have to verify you're an adult, not like, oh, the system has to guess, or if it thinks you might be, you actually have to verify and treat kids differently than users. I think you'll see a bunch of state laws that then embrace that and have a whole different set of questions in front of courts that have to do with specific harms and will bolster how this evidence gets incorporated. Right now, you don't even get to that step in the analysis if they toss something out because it wouldn't matter technically. And so I think that that's going to totally shift the focus.
Super interesting. Matt, you had to speculate.
I'm just pondering Meg's take. I like that. And Brett Frischman's always talking about age gating and I'll just say on that, something that in support of Meg's take is that sports betting legalization is also going across the nation. From my perspective, it's a cousin, if not a sibling, of the social media issue because it's apps designed in very similar ways, and sports betting apps are designed using prop bets, so you get quick rewards, and it's a lot of the same issues. But sports betting is not a shoo-in for legalization; it's in the opposite position. States are in many cases ban it, and they want to be legal. When you want to be legal, you need to convince legislatures that it's not going to affect minors. So the sports betting apps have a vested interest in doing good age gating, which then develops a technology that you can go to the social media company and say, hey, if they can do it, why can't you? And so anyway, I like that take. I'll say let me do quick, a pessimistic and then a positive take. My pessimistic take is the ultimate triumph of industry. If you look at addictive industries, alcohol or tobacco, it's just not a place where industry loses. There's this famous Law Review article called Why the Haves Come Out Ahead, but industry is thinking long-term in all of the different places, in courts, in legislatures, in everywhere. you know, in marketing, whereas all the different players were thinking a state legislature is thinking myopically that year, and a litigator is thinking about winning their case. And so just that repeat player kind of long-term dynamic versus the short-term allows you to manipulate outcomes across different spaces. And of course, the more money you make off of the status quo, the more cash you can bring to protect the status quo or to steer it in the direction you want to steer it. Industry can hire smarter versions of me. They can hire more. Like it's just, and so what my big concern would be, or like the ultimate triumph of industry to me would be probably like some federal legislation or something that seems like it's going to do a lot, but ultimately entrenches the current industry players and puts up barriers to entry for competition. And we kind of get locked in our current industry play or something. And so that is a concern for me, and without meaningful protections. So evaluating federal legislation or anything, it's like a big question of like, is this going to be kind of ultimately protective of the current industry? And is it going to meaningfully check and force kind of accountability? The thing I like about tort, to stop rambling, is tort law does not say like you can't go do innovative stuff. It just says if you do something innovative and it poses costs on other people, you have to internalize that cost when you design the thing. And if there's reasonable steps you could take to not hurt them, you have to take those steps. That's all tort law does. And so the question is like, do we get legislation that actually does that, or is it something sort of? So that's my pessimistic take. My optimistic take is that the network effects here, plus person learning, do create potential for community power that aren't there with like tobacco or alcohol. You know, so especially if it's age or something, if parents or if somebody else can actually push the community into different networks or force competition, you know, on the kind of healthy, positive parts of this and away from it, then maybe that's a positive ultimate outcome. So that's my take.
Great. Bryn?
Sure. I feel like I have to take a step back at the bigger picture of what's happening around science and higher education, because that is what's really rocking my world right now, based at a university. The Trump administration's attack on the higher ed, science, research, academic freedom, free speech, all of this is making science very difficult. They are cutting, hopefully people know this is happening, but in the last 2 months, billions and billions of dollars have been wiped out for science and for higher education. This is affecting scientists, no matter what your field is. And that includes scientists who are doing social media research. In public health, we're being decimated. The public health workforce is being decimated. That's in government, but also in community organizations, nonprofits, and universities there. Now, you remember a few minutes ago, I was talking about the two-part abatement plan. One part was an internal mechanism. The second part was an external mechanism working with external scientists. Those are the people who are in the crosshairs right now because of the cuts to higher education and the threats against higher education. This is going to make it much more difficult for external scientists to be able to carry out the research that we need and the monitoring that we need to be able to keep track of what's happening in social media after these abatement plans get put in place, and to make sure that they are made safer places. Now, make no mistake, this is not bluster. This is not transient. The attacks on higher ed and science are real, and there's a high risk of really destroying the next generation of scientists. If we can't do public health education, if we can't do science education because of hundreds of millions of dollars being cut from Johns Hopkins, Columbia University, and a number of other universities all over the country, that means we won't have the scientists to be able to do all the research that's cited here. It is so important. It's so important. You talked about community power. It is so important for all of us in science, in the community organizations, people working in law, parents, kids, to be joining together to stand up for science, to stand up for the research, to stand up for higher ed and our rights to academic freedom, and to train the next generation in the science excellence. There was one more thing I wanted to say about what we've seen most recently with the alignment of Meta and X, so that's Zuckerberg and Musk, with the federal administration. A piece about that is a combination of the enormous economic and communications power of that part of the private sector with the enormous police power of the federal government. This is especially concerning about our ability to keep higher ed and the free press and the training of the next generation of scientists really healthy and robust. And that's where it's another way that social media is coming in on that with this alignment of the economic and communications power with policing power. So that is, I don't have a positive take on this, just a negative, but hopefully you'll be able to bring us back from that.
No pressure.
I mean, you really kind of riled me up, Bryn, and I maybe I want to start with a kind of call to action from where you left off. I mean, I think we have to see our researchers as, you know, whether you want to call it human rights defenders or our frontline troops, like these are the folks we need to be able to build the case for regulation, the case for litigation. And if they're not being protected, if they're being attacked, then, you know, the whole project crumbles. And so I think we really need to rally around our researchers. We need to remind and kind of related to that, the other thing that we see happening is increasingly the weaponization of the First Amendment beyond what we've seen before, such that, you know, the paradigmatic, like historical idea that the First Amendment protected people and they protected their expression and their right of inquiry and, you know, the right to kind of share knowledge and disseminate knowledge, that's all being eroded, right? Right now, in terms of how the First Amendment has been weaponized. And so I think we absolutely need to be thinking creatively about how we protect our researchers using the First Amendment kind of where it should be placed, as opposed to, you know, these corporate entities having more First Amendment rights ostensibly than researchers. So that's one just call to action I'd make there. I think the community power point can't be overstated. You know, a big part of why I formed the Tech Justice Law Project is that there's just a lot of people in this space who are not connected. We're not working efficiently. And so the more that we can bring, you know, different disciplines together, but also just different communities, law professors with litigators, with, you know, community groups, with AGs, like the better off we are. And that's true for discovery. That's true for kind of every stage of the litigation process as well as the regulation process. So we need to stay connected. We need to bring scalpels to this project, right? Like we can't just talk about, oh, we want this new legislation without thinking about, well, how are we talking about this in a very nuanced way that's going to survive constitutional scrutiny and it's going to be effective at trying to address the harms that we're trying to address. Not just, oh, it's great to like be involved with, you know, a legislative project that's moving ahead. Maybe I've been burned one too many times with state laws that have been attacked in the courts, but I think we absolutely need to save resources by thinking more strategically at the outset, which is why a few of us have like formed a constitutional vetting group where we invite people to bring their, you know, legislative proposals to us before they're introduced in the legislature, and we can save a lot of resources. We need to be very deliberate about how we engage. You know, industry is whining and dining. Judges, AGs, we don't have the resources to do that, to go take them on an all expenses paid, you know, trip to Hawaii where they talk about AI, you know, and their perspective on AI. But I do think that we need to start penetrating those rooms like, you know, the National Association for AGs or, you know, whatever the National Judicial Council is, and start thinking about how we can really raise the bar in terms of making sure that we're all kind of speaking the same language and we're kind of operating from the same set of information. And, you know, this last kind of call to action, it's tough because but it's a recognition of the fact that we're guided by different incentives. I think one challenging thing for me is that a lot of litigators in this space are private litigators. And we need to figure out a way to kind of reconcile the kind of profit imperative with the need to really push for the social good. So when litigators are at the point of settlement, that they're not just kind of getting a cash settlement and saying, all right, it's, you know, we'll call it a day, but that they're really seeing the kind of really thoughtful abatement plan as a part of that settlement negotiation. So I think we really need to try to incentivize however we can, you know, folks that may not be otherwise incentivized to think about the social good, to be thinking about these broader, and I think that requires communication, that requires collaboration. Now my pessimistic, so that's my call to action. What I'm seeing though, in terms of where the industry is going, is that there's new arguments that they're advancing in courts that we haven't talked about here, and that concerns me. An argument that won last week is this idea that if you write a law to say this law covers businesses that kids access or kids are likely to access. That the definition itself of the law is content violative, right? Because you're discriminating between which sites come within the coverage definition. And we saw a judge last week in California accept that argument, which means it's game over from the word go. If that's how the law is worded in terms of who it applies to, you don't even get into any of the harms, you don't get into the design arguments, it's over at how you define the law. So we have to be super, I think, careful about how we phrase the legislative proposals that we're advancing. We are involved in a case involving children who've been harmed by AI companion chatbots. And what we've seen industry do here, which is currently being litigated, is that they haven't advanced 230. They have not advanced the First Amendment rights of companies. Instead, what they've said is, this is speech. We don't know whose, but it doesn't matter because our users have the right to listen to it. So this is listeners' rights are a part of the First Amendment, yes, but are listeners' rights valid if there's no speaker? So I think this is where we're headed. And meanwhile, these chatbot companions have gravely harmed our clients. In one case, our 14-year-old client committed suicide. Now, if they're going to be able to evade that kind of scrutiny about who the speaker is and still advance a First Amendment argument, I think that's something that should concern all of us. And we really need to be thinking about kind of bringing our creativity to new and twisted interpretations of the law.
Great. Thank you, Mitali. Thank you, everyone, for your, at times pessimistic, I suppose, vision of the future, but also some concrete steps. As promised, really want to open up the conversation. We have about 30 minutes for questions, comments. I'd invite you, if you're comfortable, to introduce yourself when you make the comments, and we have mics just up in the ceiling, so it should be picked up on the live stream. So I'll start in the back.
Ryan Crow, I'm with the R Street Institute. And this is really a question for anyone who wants to take it. So the new administration and at least some members of the new Congress seem more willing to take on Section 230, but perhaps for different reasons. So I'd be interested in anyone's take on how that might help or harm your strategies, and whether that's sort of a kind of false friend scenario, or there's something there that could be built on.
I was at an American Enterprise Institute event a couple weeks ago on like family technology policy, and one of the speakers talked a lot about Section 230 in a way that I thought was a little bit of like interesting bedfellows moment. But it really got to what Matt was saying, which is like, this is what tort is about, and people of like a handful of different political persuasions are really into, instead of regulation, having tort law like work the way it's supposed to. And so Section 230 was like just kind of gunked up the spokes of how the market and a really strong tort system is just supposed to be doing a bunch of this work anyways. And so it was pulling in some pieces. So this was kind of libertarian, new right libertarian meets, sad, grieving parents on the Hill, like sort of different ways of getting at it, but same outcome.
I would just say that, I mean, I know in my kind of travels and talking to different groups, there's absolutely kind of very genuine concern for these issues on the right, like that it's not a partisan issue. So I think, with any Congress, if people are hoping for reform, it's like, there's reason to hope. I do think that, the concern I mentioned about legislation winding up not doing as much as maybe reformers would hope, and then doing things that industry might hope, is always there. And so that's not partisan either. That's just kind of a challenge. But I've definitely heard a lot of, in Georgia, we have almost like a split within the Republican Party, where there's maybe a more free market, and then there's a more kind of concerned, especially with the kids and some of those issues.
I suppose I'm fairly pessimistic about federal opportunities for bipartisanship. Just what we've seen over the last several years, spanning different administrations. I'm much more optimistic about the ability to get things done at the local level. But I agree with Matt that I think that there can be a lot of unintended consequences of legislation. So I would say, maybe we don't need wholesale regulatory frameworks. Maybe what we need is to kind of tweak the product liability law in Florida so that it allows us to bring a case around defective products in the social media context or the Gen AI context. Sometimes the tweaks we need aren't grand because we do have this history, I think, over centuries of consumer protection and product liability really adapting to respond to developments in new technology. So that's just to say, like, if we can't get the legislative framework that's going to make all these changes, maybe we do things that are smaller and make changes in laws that really allow us to kind of invoke state laws, work with the AGs, who I really see as like some of the most important offices right now in the country.
Yeah, and I mean, just to say with the MDL, as I said at the outset, like the fact that you have 42 states aligned around those claims shows quite a bipartisan commitment at the state level to investigate and hopefully address alleged harms. Any other questions? Alyssa, please.
Alyssa Cooper, I'm the executive director of KGI. Matt, when you were talking about causality, I felt like there was one section that you didn't get to that I would love to hear your take on, which is specifically in the context of product liability. So, and the sort of standards of evidence, and there's like lead paint in a kid's toy or this kind of thing. Can you talk a little bit about the standards of evidence in the context of existing product liability that might map most closely to some of these cases?
Yeah, in the public health area, we've had, like, you get very it's the most challenging area, but with toxic torts and like asbestos and some of the pharmaceutical claims that we've seen, you get very difficult issues of kind of causation that depend also on who the plaintiff is. So like in the opioid litigation in Ohio, the plaintiffs are often counties and states. And so they're not necessarily, it's part of the claim that there's alleged harms to individuals who had an increased risk of addiction, but then they're also, it's their job to show kind of carry-on effects. And so you see me kind of saying, like, you've kind of got to get into the nature of the specific claim in order to see what like evidence you're going to need. It's going to be the rare case where you actually have to prove a nationwide effect or something like that. It's also going to be ex post, like, did this cause the thing? Whereas often in medicine or in clinical work, they're kind of thinking ex ante, like, does exposure to this cause this? And we're trying to figure that out. Whereas in the court context, you're looking like, look at this person and did they wind up causing this? The closest case for the specific person being caused addiction is in the tobacco litigation. This was one of the big stumbling points. The reason the tobacco companies won for 40 years and were always able to beat back litigation is they could say there was intervening choice of the smoker or something like that. And so ultimately the courts wound up developing standards of finding that this cigarette caused this addiction or something like that. And then the last thing I'll say on this is it's one reason that I think addictive design and focusing on design is very useful. Because like when in this tobacco litigation, things like adding menthol to cigarettes, which were shown to have an increased risk of addictiveness, you could then kind of attack that on like a products theory without some of the underlying challenges like an individual being addicted by it.
Any other comments on that? I mean, I guess maybe Matt, just to sort of pull on the tobacco example. I mean, it's an example that's brought up in this context, particularly around access to information and data and evidence. So like the degree to which those companies were able to do studies internally and then not have those studies be scrutinized. I'm curious what sort of analogies you see or what lessons you see for this moment around social media companies, doing the A/B tests that Meg referenced, doing these internal tests, but most of us on the outside never getting to see them unless we go and work at a company.
One, I think I'm very interested to see what comes out of discovery and depositions and everything like that.
Mm-hmm.
I think one challenge is that I'm guessing that I don't know, but that the tech companies kind of learn from the tobacco companies' mistakes. So you wouldn't keep 15-year-old files in someplace. Instead, for efficiency reasons, you would adopt an auto delete policy after 4 years or something like that. And so I don't know the specifics of the data handling at the company. So that's kind of an open set of questions. And then there's another challenge here too, of course, which is that like I don't in any way when I say industry mean to like cast aspersions. We have a market system that does really awesome things where people work very hard to meet consumer demand. And you do that with addictive products too. And that's why maybe you need to regulate to fix it or something. But the people working in industry are following the incentives our system gives them and trying to create value for like and all of that. The like tricky thing about social media is if you're trying to maximize engagement and you've built an algorithm that's really good at maximizing engagement, the algorithm might have figured out that more stimulating pro-Anna content is what engages a person. But you don't even know that yourself. And then the question is, would you even look into it? Or is it better to be, so my understanding from what I've heard of some of this is that like the companies might the algorithms kind of variables might well understand if a person's their age or their gender, but the company wouldn't actually have a file that says age and gender of person. Instead, they've got some algorithmic score that I couldn't even interpret that's just always happens to be 13-year-old girls, right? But then they could genuinely say, we don't know who the 13-year-old girls are. We haven't even mapped out all of those things or something like that. So there's these complexities that I'm not envious of the litigators to figure out. As an academic, in a way, I kind of want to read it in 2 years, read the cases and see how they all get worked out. So there's similarities and differences, I guess, is my long-winded, the short answer to my long-winded.
Could I ask a question of Matt?
Please.
Is that?
And then Meg, come in.
But I'm curious, like in the MDL and its state counterpart, the JCCP, there's been, hundreds of claims brought forth by school districts, as you know, alleging that these products are addictive and that the harm they've encountered as a result is the kind of deprivation of sleep, poor performance in school, the fact that they've had to divert their resources as a school district in order to address these harms. Now, in the JCCP, I understand that those claims were kicked out because it was seen that the platforms don't have a duty to school districts. What have we learned, I guess, from like whether it's opioid litigation or tobacco or any of these other kind of broad-based harms that could help when we start to kind of expand the remit of harms that we're looking at?
Yeah, I mean just on that, the duty question in opioids is one of the core issues. So when you see courts in different, like Oklahoma versus Ohio kind of coming out differently, it's often whether or not there's a duty owed and whether or not it was violated. In some cases, they piggybacked off of so that, like in the opioid cases, they would piggyback off of CSA, DEA kind of duties. And so you violated that and therefore there's like, you get to the theory. This is one place that the federal law might interact. If you have federal legislation or even state, it can then piggyback as either like creating a duty that might be breached or actually showing that you've satisfied the existing requirements. And so then there could be, even if there's not direct preemption, it could kind of interact with the tort standard in those ways. So that's like a lawyerly non-answer on exactly like when someone has a duty or something like that. I guess the shortest litigator answer would be like, it's going to depend on the district.
Yeah.
It's going to depend on the case law. It might depend on, and then kind of the facts of the underlying case.
Meg, do you want to say something?
I was just thinking about this question about the difference between tobacco internal studies, what they know, versus technology companies. And I do think that there's potentially a big difference, which is that is what they sell. Tech companies sell being able to target specifically to users and engagement. And so if you have a social robot and you can tell an advertiser or an investor, we can keep people on here 3 hours a day. How do you do that? Like there's documentation in some of this stuff because it's part of the sell to advertise to third parties that you can access, that it's a little different where you're not selling the bad part of cigarettes. You're sort of selling the bad part of tech companies. That's the part that's really profitable. And so if there may be more visibility into it.
That's interesting. And I know like with tobacco and then opioids, I mean, when you start to go on the industry participants, like I don't know if they're seeking discovery against companies that advertise through the platforms who might have retained some of that messaging that wasn't retained by the technology companies. That's just a question I don't know the answer to.
Super interesting. Questions? There was one in the back.
I'm Mary Pat Dwyer. I work at the Tech Institute here at Georgetown Law School, and I teach a couple of classes here on social media issues. I was hoping to dig in a little bit to the consent decree and abatement plan points that came up. I think it's awesome and creative, but it has a couple of hurdles. Mitali mentioned one with the sort of centrality of private litigants, but I think there are a couple of others in terms of sort of judicial philosophy and what they're used to thinking about when they look at remedies. And one is sort of what's the quantifiable benefit that's going to the individuals in this case who are harmed. And that's a little bit more attenuated from some of these other broader remedies. And I think the other one is this question of sort of, is this the type of thing that we want courts to be involved in, that we want courts to be supervising? And there are obviously a couple of historical examples of contexts where courts have said, okay, this is just so bad that we have to get into this. It's like racist police departments and abusive prisons. And they typically involve, a pretty concrete connection to human grievous harm or death. Sort of how do you make that pitch to judges that this social media context where the research is maybe there, but a little more debated. You have the industry people saying, it's not there at all. How do you sort of make the pitch that this is a similar context where courts should be getting involved in those atypical remedies in that extensive way?
I would say piggyback off of privacy litigation. We have a bunch of consent decrees that kicked off millions of dollars for research at places like Georgetown Center for Privacy and Technology. So I think we have some examples that it would make courts feel more comfortable saying like, we have some big gaps here, and making plaintiffs whole isn't gonna feel complete unless we do some of this more structural design work. That would be my first pitch.
Brent, do you want to comment on any of that?
I don't think I.
Okay.
And I'll just say that I think, the point about who the plaintiff is in all these questions, that this goes to the point about who's the plaintiff and can schools get in? So like it seems very straightforward to me to imagine that like an AG's group would find a settlement that involved prospective relief and something like that desirable. You're right that if it's a kind of individual money claim, that might be harder to kind of sell the individual plaintiff.
Great. Sandra?
Everyone, my name is Xander Arnau. I'm also at the Knight-Georgetown Institute. I guess we have a lot of questions today. I guess I wanted to tug at the age verification thread that got mentioned. I guess it's not something that I'm deeply familiar with, so I'd be curious to hear like what's the state of like the sports betting and how that's affecting what kind of technologies are viable, and maybe for the sake of the answer, like assuming that it's constitutional, like how might like its deployment affect claims about product design and in future litigation? You talked about tort law, like you have a duty to take reasonable steps to resolve these harms, and it seems like if age verification can be reasonable, or if it is viable, that might fold into that kind of remedies discussion. So I was just curious to hear about that part, if you know anything.
Maybe I'll just tee us up and yeah. So we stopped doing age stuff after some cases in the early 2000s, basically 98 and 2000s, where the Supreme Court looked at it, and this was Congress passed a law, the Child's Online Privacy Act, and it required knowing who was a kid, and you had to do certain things. You couldn't show them certain things, disturbing things. And they were like, age verification is going to be this huge burden. We don't understand how it would work. Like, how could you show a website in 1998 your ID, or what would that look like? And we just let it go for, 20 years. And then recently, a bunch of, I think the public health, mental health crisis around kids just got people saying, we got to try again. And the technology has really changed, and we're all pretty comfortable or familiar with something on our phone that probably says how old we are. For instance, lots of people have like family sharing arrangements set up with their devices, things like that. And gambling online and buying booze online got really popular. And so there's just this like familiarity with having a computer that an aspect of your computer that really could easily send a message that says this person's an adult. It doesn't say anything else. It just says you're an adult, or it says you're in a certain age category range, that got people interested in putting these laws together and putting them in court and seeing if they would pass constitutional structure. The scrutiny. The first of those were porn. And those are the ones that have made their way to the Supreme Court. So these for pornography sites, they have to age verify. So Pornhub has left Texas because it couldn't put this, it brought this claim through its industry organization instead of putting that in place. These design features, there's a couple of other ways that they do this. One is the likely to be accessed by kids. We also have a whole Child's Online Privacy Protection Act that already addresses how platforms that are directly directed at kids or have actual knowledge a user as a child, they have to treat that user's data in certain ways. So that has a long history. And which of those get past First Amendment scrutiny is like newly up for grabs because of the different technologies that we are using. Is that, yeah, what else? What did I miss?
Can I just ask one follow-up? You mentioned that you think SCOTUS this spring is gonna
Yeah.
rule that age gating is constitutional. What specific approach to age gating do you think that they're gonna say is okay?
I don't think they will say a specific one is okay. I think they'll reference some things and say, well, we think that these can work. So this idea that this is impossible or that it necessarily violates people's privacy is not categorically an accurate way to capture the technology.
Yeah, I think I agree with you, Meg, and I think that they will cabin that by saying that there need to be, like, these technologies as they develop need to be shown to be privacy protective and balancing the kind of competing values that are at stake here. But I do just want to pick up on one point to kind of reveal or highlight the duplicity, I think, of industry's arguments vis-a-vis age verification, which is that in many instances, we know that the platforms already have collected data from children and know exactly either with precision how old they are or certainly within an age band. So again, the idea that, we're not necessarily suggesting that platforms need to collect more data, but that if they've collected data, that they can use that for the very limited purpose of, age estimation or age assurance and delete it. But we know that it's an argument that they're kind of using both ways because they're saying, oh, this violates the privacy rights of our users, but meanwhile, they're collecting data right, left, and center from our kids.
And I would just add, there's a tort doctrine that you get like around swimming pools, which is attractive nuisance, that like if you have a pool out and you don't put a fence up around it, then a kid might fall in. And kind of the argument out there has been to claims that are like, that, hey, Snapchat is like a pool and you didn't put a gate up around it and the kid's falling in. Often the text kind of arguments are that there's no such thing as such a gate. We can't build such a thing. And it does seem like foreseeable that in the next 10 years, or much sooner, it'll be like, well, no, you can build such a
They say it's
gate.
impossible. It's
And
just
yes, someone might
expensive.
be able to climb over it or something like that, but you can do quite a lot of good by putting that gate up. And then once you kind of establish that, then you get opportunities, maybe it's just a tort suit for attractive nuisance and failure to put up an age gate. Or maybe it's a state law or a school specific, like the state could say, we don't want, these apps available in our schools or something like that, unless, if they are permitted for that use or something like that. And you just get additional kind of regulatory tools just built on this kind of age thing. And then the final, like the constitutional piece is some of the public health interests are specifically for minors. It's like psychological and physical well-being of minors, not tested exactly how old you have to be to still be a minor, but that dovetails nicely with the age gating stuff.
Yeah, and those points around inferred age as well relate to third parties and advertising and what platforms are saying to third parties about, age and targeting. And I think it also connects to the regulatory landscape where we see industry, social media companies in particular, pushing age verification, age assurance towards app stores versus social media. And we see a number of bills in that landscape. So definitely an area to watch. I saw another question. Yep.
Yeah. Hi, Bryce Bennett. I'm a third year law student here. I thought the discussion about kind of design defects is interesting, but especially insofar as I wonder if some of these designs that we're saying harms are downstream of, such as recommendation algorithms or endless scroll, to what extent might those be almost inextricable from the business model, such that the real cost to industry wouldn't just be making the technological changes, but that the business model can't survive without those things. So I'm just interested if any panelists are interested in rebutting that premise, or if you would agree with that. What is the end game? Is it just like tobacco, like restricting use, trying to block off, like age gating, or is there some sort of affirmative vision that litigation or legislation could have to sort of steer the business model in a different direction?
I would just tee that up for KGI since they just released a paper on recommender algorithms. The one thing I would just say before that though is like from a legal standpoint, you're right. Like I think recommender algorithms and challenging them has been seen as being intertwined with First Amendment protections. It's only recently in a couple cases, literally within the last several months, one in Pennsylvania at the Third Circuit that involved a choking challenge on TikTok, where the young person died, and there the court said, the plaintiffs here have alleged, content that was pushed through a recommender algorithm based on the child's data, and that's not protected by 230. And then subsequently, we had the Northern District of California say that a law that was meant to protect kids against addictive feeds actually was consistent with the First Amendment, and that's now on appeal. So it's only now, I think in the last 6 months or so, that we're starting to see openings on this space that historically has been seen as content. But for the business model, I'm gonna hand it to Pete.
Yeah, I think it's a really thought-provoking and great question. I think ultimately is core to the objectives of litigation. And so because Mitali referenced this, but also because it's quite relevant, we did just release a report called Better Feeds, which looks at recommender systems. And I think challenges this assumption that the only two options within a business model are maximizing for short-term user engagement or delivering a chronological feed. And exploring this middle around actually optimizing for longer-term engagement, moving from sort of implicit signals of, okay, I dwelled on this content, or I looked at this thought-provoking, shocking image, and then the algorithm learning to serve more of that content versus actually explicit preferences and user surveys and ways to actually drive that. And I think certainly you have aspects of industry who have argued that any sort of tweaks in that space would threaten the business model, but I think it's very much an open question. And if you look across the social media landscape, particularly with the rise of new platforms like Blue Sky, which gives users more ability to influence their feeds, more ability to choose different content moderation options, I think you're seeing an opening where not all social media has the exact same design features, and there can be more of a marketplace of competition for maybe optimizing for long-term value, optimizing for more explicit preferences that you have, as opposed to the industry or the system deciding what those should be. But I'd be curious if others have thoughts on that.
I love this question. I feel like it probably reveals differences among the people sitting up here. Like my personal take is I honestly don't really care if adults choose to do addictive things. Like they know that's, but I find it quite disturbing when kids are introduced to disturbing things, for instance, through school, or they don't know, or we haven't really like collectively come together to make that something an adult aspect of life that you can choose to do it with long-term effects on children. And so I'm sort of like that is where I'm more comfortable. But I think a lot of people are like, no, you shouldn't have an addictive business model, which is, I think there's also legs to stand on. I just don't have as developed an ideology in that space as I think other people do. Yeah,
and I think deceptive design also plays a role perhaps in that.
And I would agree on that. Like at a minimum, like if you're going to say it's like that, it's like cigarettes or something like that, then there ought to be a warning on the package that makes sure that the well, we restrict sale to minors, and then we make sure that someone who's not a minor understands what's happening. One of the challenges with some of the addictive design techniques is that it's not visible to the user. And so it's just never, you need the warning in order for them to appreciate, even on that kind of libertarian approach. But then I would just say, like, here, I guess my knowledge of the industry runs out. So I'll say this as a lay person or something like that. But like Hollywood's business model is to get people to go to the movies. That produces a lot of nice things in art and everything. And social media does a lot of really nice things. It builds communities. It helps people create. It does like a lot of really nice things. It's just one of the ways they get people to engage right now is by using psychological tricks, allegedly, to foster compulsive use. So the person doesn't go to use it because, like the Lord of the Rings, I love to read the Lord of the Rings because it's so compelling, or like, some chat group that I have friends in, it's just like there's great friends there. Instead, they're going to use it because the device has been designed in a way that's got them hooked, and they might even be doing it when they're not even thinking, and they might be constantly deleting the app and reinstalling it. I'd love those numbers from the companies, by the way. So on that theory, if you believe in internet innovation, then the dream would be that currently it's not a level playing field. If you wanted to launch a social media app, you would have to also engage in addictive design so you could build a network and be the popular social media app. And if we properly regulate to prevent the addictive design piece, then the companies will still innovate, but they will innovate to produce a product that brings more people together and allows them to create more and has better content. They're just not competing on like who's got the most addictive way of doing this or something like that. So that's one version of kind of the dream of that, I think.
Just one point I want to add about the question of whether we should care if adults are being brought into addictive things. You gave the example of opioids before, but there's a state interest in that. You talked about the state interest as something that's important or why we would give vaccines and that kind of thing. There are costs when these companies are using deception to get people to gamble, or people who are addicted to gambling to keep doing that. There's costs to society. Somebody's picking up the tab while somebody else is profiting from that. In the public health field, we approach this as an area called commercial determinants of health. What are businesses doing to change regulation, to influence courts, and to influence consumers through its addictive design or changing the architecture of what's available to get people to buy their products? And then those companies are not paying the tab. If people are getting addicted to cigarettes, or the way that the companies making opioids manipulated systems that got people addicted and outright lied to get people to use these products. That costs money to the state. It costs money to all of us and has consequences for lifespan, people's ability to participate in their families and their communities and society, work, school, all of that. And it can all be costed out. It's not just speaking in the abstract about these things. We do studies to cost this kind of thing out. And actually, I just thinking of the group I lead, the research group I lead, Stripes, Strategic Training Initiative for Prevention of Eating Disorders. We're developing using methods from public health of microsimulation modeling to try to model out the effects of those design features. So not the eating disorder content, because we know that's a non-starter in court, but to cost out what is the impact of the design features and how is that leading to bad outcomes that then society has to deal with, families, individuals, society has to deal with, both from a causal perspective. I know we have a higher level of what we need to be able to call something causal. We're doing that. But also we can use those in our economic analyses, which we've done in other kinds of studies. I'm actually going to be following up with folks here and some in the audience too, because we're going to be bringing in an expert panel to provide some of the data we need for that microsimulation modeling. But we can make this empirical, and then we have the data to give back to courts or state lawmakers to start making putting in more constraints on what these companies can do.
Amazing. Well, those are the exact interdisciplinary collaborations we're hoping emerge. Maybe we could take a final question. Sure, Morgan.
Yeah, so you briefly touched on this trend and more user demand to design their own platforms. You gave the example of Blue Sky. I wanted to dive deeper into the idea of user rights. So the ability of a user to develop or design what sort of, or opt into or opt out, this sort of design features that they want to see on their platform. Is there a regulatory or legislative solution here, or is this something that's best served by free market competition?
Is the question about like design features, whether users should be given more. Actually, I think I understand the question. Let me start. Okay. So Paul, who left now, he and I did this project last year where we looked at the iPhone iOS update from a couple of years ago. If you have an iPhone, you know the first time that you open an app, you have to make a choice about whether the app should share with third parties or not. Do you know what I'm talking about? So there's this like forced choice. Nobody made them do it. Tim Cook just supposedly got mad at Mark Zuckerberg, and that was, whims of billionaires is the name of that game. Prior to that, there were two defaults, and they both kind of supported what were perceived as some good outcomes. So when Mark Zuckerberg got mad about this iOS update, he took out some full page print ads in the Wall Street Journal and the New York Times, where everybody reads them. And he basically said, Apple hates small businesses and the free internet. And the argument was that small businesses thrive on targeted advertising, and that free high quality content is better served with a non-subscription model. And this is kind of like the pros of surveillance capitalism, like laid bare in the Wall Street Journal. It's like, this is the push. And they were I think there's like real buy-in that those are real goods that their business model supports. Most importantly, their default supports that. So the default being an opt-in data sharing. An opt-out data sharing. So they're going to assume this is what we all want. And if you have objections to it, you can like change the default, but nobody changes the default. So we all are like moving, this is what study wants. Europe has the General Data Protection Regulation, GDPR. And they sort of said the opposite. They're like, we actually don't agree with those outcomes. We want other business models. We want other user rights. And so we're going to have an opt-in model for data collection. You have to give real consent. And then you have like the Tim Cook. So that's a different default. And then you have this Tim Cook that's like, I'm not sure about surveillance capitalism anymore. Like, well, let's just let users decide. And so Paul and I took this as an example of like kind of users voting and giving this input, because there's not that many mechanisms for knowing what users want like collectively. And so that was sort of one example, but it's hard to engage in those default conversations. Those happen at different levels. And one place that they do happen at a level for public engagement is for the universal opt-out mechanism, which a bunch of state laws are invested in. That is a standard. Alyssa Cooper over here, this is our standards queen. But that's a standard that's being worked on publicly. Like if you care about that, you can go on, it's a GitHub page. It's the W3C, the World Wide Web Consortium is working on it. And states are committed to legally giving that force. And so there are a couple of ways. Some of them seem real macro, where it's like vote harder, and then others are like buy an iPhone, but there are ways to publicly engage in the actual default standards.
Thoughts? Great. Well, thank you all so much for coming. I think it's been a really thought-provoking conversation and really appreciate you taking the time. So I invite you all to thank us. Great.
Thank you. Great fairness to follow up on a number of things.
Yeah, absolutely.
Business model.
Thank you both.
I know.
Fantastic hearing it.
We're offline.